Yes, sir.
Good morning, Mr. Chief Justice, and may it please the Court. My name is Warren Brody, and I represent the appellant Trace Construction, Inc. I will be arguing for Trace and also for CB Seating, Inc. Attorney John Curran, who represents LC Anderson, will be arguing for LC Anderson, Inc. and also for Quinn Brothers of Essex, Inc. Trace filed suit in the Superior Court against Dana Barros Sports Complex, LLC, and Richard Madigan as trustee of the Oxford Road Realty Trust. As against Madigan, the complaint contains a single count seeking the enforcement of a mechanics lien under Section 2 of the Mechanics Lien Law, Chapter 254. CB Seating also filed suit against the Sports Complex, LLC, and Madigan under the same statute. Quinn Brothers of Essex and Anderson filed suit under a different statute, Section 4 of Chapter 254. All of the claims were consolidated in a single action. And then Madigan filed a separate complaint under Section 15A of Chapter 254, seeking the summary discharge of all four claims. That action was dismissed by the Superior Court, which dismissal was affirmed by the Appeals Court in 2007. This case was then tried in the Superior Court, jury waived, which resulted in a judgment that found that there are amounts due to each of the claimants. However, the mechanics liens can only be enforced against the leasehold interest of Sports Complex in the subject property.
Now, if I could, assume you are correct that the consent of the owner is sufficient to make the owner of the property responsible for a mechanics lien, or liable under the mechanics lien. Yes. What do we do with the judge's finding that there was no consent here?
The judge found that there was no consent by Madigan to the entry of a written contract between Trace and CB Seating on the one hand and Complex on the other. He did not find that there was no consent totally. He referred specifically to consent to a written contract. That is to say, he was not shown any particular written contract between Trace and the Sports Complex. That doesn't mean, Your Honor, that there was no consent. Mr. Madigan was shown a drawing of what was going to be done before any work commenced. He drove past the facility twice a day on the way to his nearby office. He visited the construction project 2 or 3 times during the process of the work. He testified that he knew he could consent or not consent to the work being done.
Excuse me, didn't the judge say that there may have been passive acquiescence here? And didn't the judge say something like that? I
believe so.
And couldn't we say that the passive acquiescence may equal consent and that on these facts it does?
I would agree.
But is it part of your argument that given the language of the lease, that he, Mr. Madigan, had an affirmative obligation to withhold consent? In other words, to say no, and if not, would be it would be inferred that he had consented? You're not going that far.
I haven't gone so far in my argument. I would note, though, that the lease was a manuscripted lease. It was drafted by Madigan's attorney. It gave him very specific rights with respect to the construction being done, including the right to insist on written consent in each instance. I would say that he waived those provisions. And if he waived those provisions, he ought to be stopped to complain that he didn't consent.
Well, the lease provided that they could not make improvements without his consent.
That's correct.
And they went ahead without his written consent, at least.
They did. That is clear. The judge found that there was no consent to the entry of a written contract. But again, whether he consented in another sense is, I would aver that he did.
Okay. Now, if we can turn, what do we do with the two phrases, one of which speaks of acting for, on behalf of, or with the consent of, and the second phrase omits the with consent of and leaves only on behalf of? What are we supposed to do with that?
I would ascribe it to legislative inattention. It ought to be inferred in the second clause as well as the first, because it clearly just requires consent, the consent of the owner.
Well, there can also be some intervening agency, can't there?
Well, if there is an agency between Mr. Barros and Mr. Madigan, that would be sufficient to
On
find-
behalf of.
On behalf of, it would be sufficient to find the on behalf of being satisfied.
The lawyer for the landlord, or the lawyer for the lessor, presumably might be in a position to be, well, I don't know if it's giving, it may be the same as giving consent. But it would be giving consent on behalf of the owner. There could be some intervening agent.
Indeed, there could.
Is it your reading of the statute that, I mean, I know the judge read the owner of any interest in real property to mean Barros or complex or camp. Do you read it as being both?
Yes, it certainly could be. That is to say,
But how are you reading it?
okay, a person entering into a written contract with the owner of any interest in real property, read Madigan as the fee owner.
Okay, but you're saying that could also be the owner of the leasehold interest?
It could.
Okay.
Or with any person, meaning Barros, acting for or on behalf of or with the consent of such owner, Mr. Madigan, etc., shall have a lien, and I note it's a lien on the property, land, building, structure, or improvement owned by the party with whom or on behalf of whom the structure was entered into, again, Mr. Madigan, as appears of record on the date when notice of said contract is recorded in the Registry of Deeds. And at the time that Trace's and CB's notices of contract were recorded, the only owner of record was Madigan as trustee of the Oxford Road Realty Trust, there being no notice of lease having been recorded.
Mr. Brody, what happens when a tenant when a tenant enters into this kind of arrangement with a contractor and improvements are made? It is made without the consent of the landlord, and after a year after the work has been completed, the tenant stops paying the rent and the landlord terminates the lease. What happens to the lien under those circumstances?
If the lien has not been satisfied?
Yeah.
It's not an argument that I spent a great deal of time on, but under Sections 23 and 25, it's argued by the subcontractors. In this case, the surrender of the lease is a conveyance of an interest in the property that takes with it the mechanics lien, so the property is still subject to the mechanics.
But I thought the judge was making a lot about the fact that this was a voluntary. Here, there was a voluntary transfer of the lease as opposed to an involuntary surrender of the lease.
I think the voluntary nature of the transfer bolsters the case. If it were involuntary, that is to say a termination, it may have terminated the lien along with the lease.
Well, that's why I asked you about he stops paying the rent. What happens in that situation?
If the lease is terminated, it's a more difficult case for the mechanics lien claimants. But here the lease was surrendered and carried with it the liens. I would like to address the issue of the lien on the improvements. I argued that Trace and CB should have a lien on the improvements, and Judge Moses held very simply that the mechanics lien law does not operate to create liens on individual pieces of property. He didn't say why. He only said that a literal interpretation in the statute does not provide such relief. And I respectfully disagree based upon a literal interpretation of the statute. And let me read it for you. A person, read Trace, entering into a written contract with the owner of any interest in real estate, read Barros, or the sports complex as lessee of the property, shall have a lien upon such improvements owned by the party with whom the contract was entered into. Read again, sports complex.
But even if you're right, is it your contention that those improvements can be removed from the property if there's a material risk of damage to the underlying real property?
No, but that was something that was not examined by the court. The court looked at the rights.
I thought the judge essentially found that the HVAC and the other improvements were not removable without material damage. Weren't there findings that he made?
What he found, no, that is not what he found exactly. What he found was that he looked at the mechanics lien claimant as being limited by the rights of a lessee, and the lessee only had the right to remove its personal property, equipment, and trade fixtures. I don't think that would include water heaters, even if the water heater could be removed without damage. I don't think that includes light fixtures.
But why wouldn't this be governed instead by, or why wouldn't it be preempted in a way by the Uniform Commercial Code? If you want to remove a fixture, why don't you record a security interest in the city hall and enter into a security agreement with the landlord, with the tenant, so that you can remove your fixture if there's a default in the payment?
I suppose that could be, but I doubt that would happen in the context of a construction contract with mechanic lien aspects.
Because you've already recorded the lien.
You essentially have a competing system of enforcement of security interests, the mechanics lien and
Well, but one
Uniform
sort of
Commercial Code.
focuses more on the item as personalty, or removable personalty, whereas the mechanics lien seems to be talking about an interest in real estate.
until 1996, when the word improvements was added to the statute.
What happens, though, in this case, if you have, because you have, the part of the lease is that the improvements go to the landlord? So, do you have an issue there?
The improvements go to the landlord as of at the end of the lease term. And here we had a surrender. I suppose it'd be relying on the fact that there was a surrender. At the time that Trace filed its notice of contract, the improvements were owned by a sports complex. Let's look at that moment in time.
I'm sorry, we're going to have to leave it there, sir.
Thank you.
Good morning, Your Honors. May it please the Court, my name is John Curran, and as Attorney Brody said, I'm here on behalf of L.C. Anderson and Quinn Brothers, the subcontractors on this particular project. We filed our liens under Section 4, different than Section 2, and what I'd like to address quickly is survivability and merger of the lien into the fee interest.
Could you also address the difference in language between 2 and 4?
Sure, absolutely. The Section 4 is different than Section 2. The wording is different. However, the statutory scheme is the same, and there's no reason why subcontractor or sub-subcontractors should be treated differently than general contractors under the lien law.
You also have rights against the general, don't you?
We have contract rights, yes, and we have a judgment against Trace Construction.
So, just playing that out, let's assume that Trace under 2 has a valid mechanics lien against Madigan. Even if you didn't against Madigan, you do have it against Trace.
That's correct, Your Honor, and that's why I'm relying on the excellent argument of my brother, Mr. Brody.
So
and
yours
that's
is a
true.
sort of belt and suspenders, correct?
That's correct, and that was made clear in the court. This wasn't double dipping, that the mechanics lien of Trace was inclusive of the mechanics liens of Quinn and of Anderson. Their number, the total number that they had in their judgment on the mechanics lien.
It really is belt and suspenders.
Not necessarily, because in many situations, in this case it may be, but in many situations on a construction project, the general contractor may choose not to file a lien on the project, so the subcontractor has this independent right under Section 4. So in this case, it's a little bit of belt and suspenders. If he wins, we win irrespective of Section 4, but I would say that they are independent of each other, the liens themselves, and we're not seeking any double recovery in this particular case.
No, I know that. I just was,
Yeah, and the language in Section 2 is different, but I would suggest that in cases before this court, most notably the Friedman case, which dealt with the mechanics lien, and the Peters case, which dealt with the payment bond statute, which is kind of the public equivalent of the mechanics lien. In those cases, this court has recognized that there really shouldn't be a distinction between these tiers of subcontractors and material men. And in fact has interpreted the language of 14929, the payment bond statute, the term subcontractors, a contract with a subcontractor, to mean all subcontractors down the line have the right to file a payment bond claim. So there should be no distinction between those tiers. And in this case, we're arguing between Section 2 and Section 4, there really shouldn't be a distinction between a general contractor and a subcontractor. Both parties are providing labor and materials to improve and benefit a property. And in this case, that's exactly what happened. This was essentially a warehouse, a metal warehouse, a large metal warehouse that got turned into a first-class fitness facility, 4 basketball courts, a large weight room, an indoor soccer area, batting cages. And Mr. Madigan, when the lease was forfeited, came in and hit the ground running, actually used Barros employees and continued on with the facility where he continues today.
If I could ask you about the merger argument.
Yes.
Here's what concerns me, and you can respond to it. If you are right, and if we say that because this is a voluntary surrender, the owner in fee now has the mechanics lien against it,
Yes.
would that not mean that when the next circumstance like this arises, the fee owner is going to say, I know that you want to essentially voluntarily surrender it to me, but I don't want to deal with the mechanics lien. So I'm going to terminate you and make it involuntary, and that's going to protect me from having the mechanics lien. Why is that a sensible rule, or how do we address that?
Well, I think 2 things, Your Honor. The first thing is under Section 4, we would allege that we have a lien on the fee
Right, well,
interest.
if you win there, merger doesn't matter. But I
Correct.
assume merger matters only if you don't prevail on Section 4.
That's right, Your Honor. And 2 issues. Number 1, as Attorney Brody said, it's our position in a termination, straight up, there's a pre-existing lien on the property, and there's a later termination, and that's key. It can't. The lien is already existing on the leasehold interest. If there's a later termination pursuant to the terms of the lease, it would be our position that that lien carries on to the fee interest. That's a tougher argument than what happened here, because in this instance, there was no termination. There was no termination in accordance with the lease, and therefore, when the leasehold was surrendered, the lien was certainly on the leasehold interest. And when that lien was surrendered, that leasehold interest, the lesser estate, was taken by the person who held the greater estate, Madigan. And when that happened, there was a merger. And that lease doesn't just vaporize. It stays on the property, and it runs with the land. A mechanics lien is in rem. It runs with the land, and hasn't been a mechanics lien case, but there have been numerous other cases which have held that liens on property, real property, survive conveyances. And
Is that true with an attachment too? An attachment on a leasehold?
I would imagine that it would be. It's a little bit different here because an attachment's judicial. This is a statutory attachment. But I would imagine that the theory would be the same. Although I think in a statutory instance, it may, a statutory lien, you may have a better argument that it does run with the land than in a judicial attachment. But I think the key issue here is that the liens just don't go away upon a surrender of the lease. The property was enhanced and benefited significantly to the detriment of these 4 contractors. Thank you.
All right, thank you, counsel.
Good morning, Your Honors. My name is Leonard Zander. I'm appearing on behalf of Richard Madigan, the trustee. Sitting with me is my partner, John Brister, who tried the case below. I'd like to begin with a discussion of the cross appeal. And there are 2 issues that are involved with our cross appeal. The first involves misnomer. None of the contractors in this case have a valid lien against the former tenant's leasehold interest.
Even if estoppel as such isn't applied, don't you reach the same result here because you dealt with the tenant as sports complex and as a basketball camp? So why would Trace be wrong to designate Barros in either fashion?
Well, Justice Cowan, it's a strict statute that's strictly construed, so estoppel would not apply. Those common law principles would not apply.
Okay.
And there are important public policies here involving notice requirements and particularly the identification of a party in the Registry of Deeds.
You didn't record the lease, right?
We did not record the lease, and we weren't required to record the lease. That was
May not be required to, but it doesn't have some impact on your ability to say, oh, you've got the wrong party here?
Well, it does if estoppel applies, but estoppel doesn't apply in theory because, again, that's a common law theory, and this is a statutory.
Let me ask you this. Was this argument raised before the appeals court? Was this part of the summary action that you sought to get rid of the liens?
No, well, the estoppel issue did not come out. It
Did
was
the
essentially a
misnomer-
privity of
How
contract.
about the misnomer issue?
No,
No?
no. In fact, there was a footnote specifically in the earlier decision of the appeals court, and it said that, it noted that there was a distinction between the basketball camp and the sports complex, and said the parties attach no significance to this, and so we need not, for purposes of deciding this appeal.
And why does claim preclusion not apply since you litigated a Section 15A matter and failed to present this argument? Why is that not precluded?
Well, Your Honor, it remained a live issue. The 15A appeal was directed exclusively to a matter of statutory interpretation and to a privity of contract issue. It was really the sole basis for that appeal and for the 15A petition in the first instance. So this was noted, this particular distinction, but it was never anything that was addressed specifically or resolved by the appeals court, and it wasn't briefed by the parties. It just remained an issue that we thought was inconsequential at the time, and in fact, that's how it was identified by the appeals court. It was not a matter of significance in that case. So again, just to go quickly back to misnomer, our argument is that it clearly was the wrong party. These common law principles of estoppel and such do not apply in this context, and we do have this important public policy of notice that applies in this case and is not satisfied in this case. And Judge Bosford, just to go back to the point you raised about us dealing with it interchangeably, just to show how it could not have even been as a matter of estoppel, something that was relied on by the parties. In this case, 3 of the 4 contractors involved filed their notices and filed all of their mechanics liens before that billing practice of my client. There was no evidence that the 4th and last contractor had any awareness of how this internal matter was occurring, and it was a mistake on our part. But in order for estoppel to apply, there has to be some reasonable reliance, and there has to be some knowledge that there was some attentiveness to the basic fact. And in this case, where 3 of the 4 could not, as a matter of chronology, have been affected by this.
From a fairness perspective, is it fair to these subcontractors? I mean, they did the work, and Madigan knew it. He saw it every day, didn't he?
Well, he didn't see it every day. To get into that issue of his, quote, consent, passive acquiescence is not enough. The cases are clear under Section 1 of Chapter 254. There are a number of cases construing consent in that context and say passive acquiescence is not enough. The only reason he happened to see this every day, and he saw it on the roadway as he was driving by, is that he happened to work in a building nearby. He was not taking any active role in monitoring the progress on this construction site. And there are detailed findings of the court on this issue. And as the court has correctly recognized, the issue of consent was resolved and was decided as a matter of fact by this trial judge.
But you have a lease which is specific in saying that Barros couldn't do this without the consent. The lease gives Madigan the right to withhold consent, the right to insist on good workmanship, the right to keep all the improvements. So to return to Chief Justice Ireland's question, given all that, is it really fair to say that the people that did all this, that are going to be yours, don't have a right to be paid for it?
Well, I guess to turn that question around, is it fair that Mr. Madigan is out thousands and thousands of dollars because a tenant defaulted, failed to pay his
He has
rent,
the value
and,
of all the
and ultimately
improvements.
left this, and he hasn't been able to find a replacement on the terms that he originally had negotiated with his tenant.
But he can run this as an operating business because all the improvements are in there. So he has the benefit of them one way or another.
And wasn't he also in the best position to minimize any losses he might incur? He could say, look, he could go there and say, stop this. I don't want this from taking place. You're violating the lease.
These are equity arguments. They invoke common law theories. One of the fundamental things we have to remember about this case is that they didn't even plead these theories. The only counts asserted against us in this case are for enforcement of a mechanics lien. So, we have to look at the strictures of the mechanics lien statute, and we're only involved here in the interpretation of that statute.
On that point, can I ask you a question? Obviously, the amendments to the statute, which were in, 1996? Pretty
Yes.
important. They came from somewhere. They meant something.
They did.
What did they mean? What was
They
the statute
did,
designed
and
to
I think
do?
it's commonly understood by treatise writers and authors and judges that it expanded the class of individuals against whom a lien could be asserted. So a lien no longer had to be asserted only against an owner of the premises, but it could be asserted against a leasehold interest or even a subtenant interest who had a possessory right or an ownership interest in the property. But just to look to the statute, our interpretation, particularly of Section 2, which I think is critical here because Section 4, to some degree, as the court has recognized, kind of bootstraps or, is related to Section 2. And the language here is that a person entering into a written contract with the owner of any interest in real property, and I'd like to stop it right there. That I think is the direct approach. In effect, it's a twofold approach to a mechanics lien under Section 2. There are two potential targets, if you will. And the first is a person who enters into a written contract with the owner of that interest, whatever that interest may be. It may be a leasehold interest, it may be a sublease interest, it may be a fee interest. The second, and then the court goes on, the statute goes on and says, or, and now this is the second approach, with any person acting for or on behalf of or with the consent of such owner. And that is the indirect approach. That's, in effect, agency language, with acting on behalf of, acting for, on behalf of, or with the consent. And that language is
So who in
is
that,
agency language, in effect.
so what, reading it that way, who do you say is in your case, the owner? Is it Barros or Madigan in those two?
In both instances, it's Barros. Madigan is not an owner with an interest in property. Well, then it goes on to speak about on behalf of or on whom the contract was entered into. So there needs to be a privity of contract, bottom line. And again, the contract has to be with the owner of the interest in real property.
Now, isn't that what you lost on in the Superior Court and in the Appeals Court? Privity of contract?
We prevailed in the Superior Court.
No, but
Our
I'm sorry,
interpretation.
in the other action, the one that was decided.
The court did not address this specific argument with regard to the such owner, the dependent clause, antecedent clause. That was an argument that was not presented to the appeals court or decided by the appeals court. And that argument was adopted by this trial judge in his analysis.
But are you bound by collateral estoppel there? Isn't that something you could have argued but did not?
Was not raised below. It has never been an issue in this case. And again, this is the basis on which the trial judge properly decided this interpretation of Section 2. So again, in our case, the written contract was entered into by Barros, by the sports complex. The alternative, if we want to look at consent or acting on behalf of, was there someone else that was acting as an agent of Barros? But there's no theory or claim here that we were ever an agent of Barros. That's the second indirect approach that would entitle you to a lien under Section 2.
I wanted to ask you something, just to pick up something you said before. You talked about 4 kind of goes with 2. Do you read them? I mean, do you read them together? so that they?
No, I mean, there's separate provisions, and I think under statutory construction principles, I was just responding to the bootstrap comment or suspender comment that was made earlier, but these are clearly separate provisions. In the case of Section 4, the subcontractors would need to have the contractor with whom they are vicariously claiming through Trace, they would need to have Trace in a contractual relationship with Madigan. And again, because Trace was not in a contractual relationship with Madigan, the person with whom Trace contracted was the tenant.
So one of the other
At best, they would be entitled to a leasehold, as the judge found below, a lien on a leasehold interest, not on a fee interest in this case. I'd like to speak...
Can I ask you one more question? One of the other things that the 1996 amendment did is it added improvements. In other words, a lien could be attached to improvements, not just the property. Why not here? Why not the improvements? This brand-new health club.
Yes, there are a couple things. First, the statute doesn't specifically... it attaches and applies to persons with an interest, possessory interest or ownership interest in property. It doesn't attach to things.
Well, shall have a lien upon such property, building, land, structure, or improvement. I don't know. Lien upon an improvement. Well, this is an improvement. It's a big improvement. Why isn't there a lien upon it?
Well, that is, and notably all the cases that our opponents rely upon are cases from other jurisdictions with differently worded statutes. But our position is it would violate the language of the statute. Secondly, and I think Judge Spina raised this issue earlier, there's notice issues here that would be profound. Is a matter of workability, how would you file that notice in a registry of deeds? How would that attach to individual equipment? Isn't that more properly a UCC filing? And
what does the statute mean then? Shall have a lien upon the improvement. What does that mean then?
Well, I think it's descriptive of the kinds of things that you can. It talks about land in that same context and buildings and structures. So it's really descriptive of the work that's being done.
But if you can have a lien, upon it, but I don't understand that. What does a lien upon an improvement mean? Nothing? Just
again, it's descriptive of the type of the character of the work that's being done. It has meaning in the context of describing. They have a right, if they meet the contractual privity requirements, they have a right to a lien because they did improvements to the property, or they did improvements to the land or to a structure. It's descriptive in that context.
But can they come in and why can't they come in and remove the building if they put up the building?
Well, that gets into the judge's findings of fact on removability, and that's a further response to the question about the lien on improvements, is that the judge specifically found in his findings are not clearly erroneous. He took a view of these premises. There were 4 witnesses at the trial. 2 of the 4 witnesses testified specifically on the issue of removability. And the judge found very specifically, as Judge Gantz noted, that very few pieces of equipment were potentially removable. So even if we found that there was a lien that attached to these improvements as a fallback or alternative position, somehow the court found that was workable given the notice requirements and the conflict with UCC filings that would be created in that situation. As a matter of fact, the judge found, and he was not clearly erroneous, that virtually nothing here was removable.
All right, your time is up.
Thank you for your time and your consideration.